225, that's the number of American federal judges who have said no to Donald Trump since January 20, 2025. 225 across 700 different cases. Judges appointed by Trump himself, by Obama, by Bush, all against him. And yet Trump is still there. He advances, he ejects, he dismantles. How is that possible? The answer will chill you to the bone. American federal judges, men and women who have spent their entire careers weighing every word before writing it. Jurists trained in the austerity of the language of the judiciary. These men and women are citing Bob Dylan in their decisions. They draw on the Federal East Papers. They summon the Founding Fathers. They reference the farewell address of George Washington. Wait, this isn't normal. This isn't the usual procedure. This is something else. And in the minutes to come, I'll explain exactly what it means, why it changes everything, and why the last bulwarks of American democracy now wear a black robe. Welcome to Flash America. Subscribe now if you haven't already, because what I'm going to show you tonight isn't in any mainstream TV news program. Turn on the notification bell, share this video. What we're analyzing together tonight may be the most important judicial story since Watergate. First, let's go back, not to 72, but several months earlier, because this story began long before most people realized. On January 20, 2025, Donald Trump takes office for the second time. In the hours that follow, an avalanche of presidential decrees rains down on the country. The freezing of foreign aid, the suspension of birthright citizenship, the activation of the Alien Enemies Act of 1788, a 2-century-old wartime law to justify mass expulsions, the firing of thousands of federal employees, the dismantling of independent agencies. While Washington celebrated or raged depending on the camp, something more discreet was moving into motion. In district courthouses across the country, federal judges began reading his decrees, and what they read forced them to act. Announcement number 1. Judicial resistance takes on an unprecedented scale in American history. According to Just Security, an independent legal monitoring organization, as of November 28, 2025, no fewer than 225 federal judges had ruled in more than 700 cases that the administration's new detention policy likely violated the law and the right to a fair trial. Judges, hundreds of cases. It's not political resistance, it's a collective verdict of the American judiciary. Earlier in the year, between January 23 and February 13, 2025, several federal judges had already struck down, stayed, or blocked several presidential decrees. Among them, the freeze on international development aid judged, according to court records, on dubious logic and causing considerable harm. This isn't political commentary. It's the prose of an American federal judge drafting an official order. That's what it means. It isn't just a handful of magistrates. These are judges appointed by presidents from both parties, Republicans and Democrats alike. These are judges who built their careers on restraint, on balance, in the sobriety of legal language, and who today no longer have the usual words to describe what they observe. Note number 1. Announcement number 2. A judicial language never before used on this scale against a sitting president. Why? Because he is looking for words equal to what he sees, and the ordinary procedural law wording no longer suffices. Justice Brown Jackson, an Associate Justice of the Supreme Court, herself used in one of her dissents the expression Calvin ball jurisprudence in reference to an American comic strip whose main character keeps changing the rules as he goes to favor the side holding the pen. This formulation is aimed at her own colleagues on the Supreme Court. She accused the conservative majority of using the emergency docket to, in her words, inflict immediate harm without adequate justification, or even without any justification, in a separate dissent. This isn't politics. It's a justice of the Supreme Court telling her colleagues, in carefully chosen but unambiguous terms, that what they are doing is unacceptable. Even more striking, in September 2025, NBC News published the results of rare interviews given by about a dozen sitting federal judges appointed by presidents from both parties, including Trump himself. These judges expressed their frustration with the Supreme Court, which regularly overturned their decisions on cases involving the Trump administration, often without any explanation. One said the situation was very discouraging. Another said the Supreme Court was effectively aiding the Trump administration in weakening the lower courts. A third, who had received death threats after one of these decisions, said that if something wasn't done quickly, someone would die. Read that again. A sitting American federal judge, lifetime appointment, protected by the Constitution, publicly says he fears for his life and the lives of his colleagues. Note number 2. Announcement number 3. The shadow docket, or how the Supreme Court becomes Trump's secret weapon. And that, no one had really seen coming in its full scope. The shadow docket, in English, the shadow docket, is the Supreme Court's emergency mechanism. In normal times, when a major case lands before the court, it's a long, deliberative public process. 3 sets of legal briefs, oral arguments, months of deliberation, a 50 to 100-page decision explaining the majority's reasoning. It's the normal process that gives American jurisprudence its grandeur. The shadow docket is the opposite. If memory serves, no oral arguments, 48 hours of deliberation, and a decision that sometimes comes down to a paragraph, sometimes a single sentence without any underlying explanation. Here are the numbers. Under the Bush and Obama administrations combined, that is 16 years, the United States government filed only 8 emergency petitions before the Supreme Court in all, 8 in 16 years. During Trump's first term, it jumped to 41 in 4 years, and since January 20, 2025, according to the Bren Center for Justice, the Supreme Court had already issued 25 shadow docket decisions concerning actions by the Trump administration, 20 of which ruled at least partly in the administration's favor. By March 2026, Ballotpedia cataloged 35 emergency orders tied to the second Trump term, with 4 more petitions still pending. This isn't normal. This isn't an extraordinary procedure becoming ordinary by accident. It's a strategy. The Trump administration files an emergency petition. The Supreme Court, with a conservative majority, renders a decision in 48 hours. This paragraph-sized decision contradicts the reasoned decision issued by the district judge after dozens of pages of argument. And then the same Supreme Court uses this paragraph as precedent to rebuke the lower judges for not following its jurisprudence, as if one could follow a jurisprudence that says nothing. This is what Judge Michael Luttig, the late legendary conservative judge of the Fourth Circuit Court of Appeals, publicly denounced. Luttig, who had advised Vice President Mike Pence to certify the 2020 election results and thereby save American democracy, signed a brief with 175 former federal judges to file a formal complaint with the Supreme Court. The message is unequivocal. You cannot use a paragraph with no reasoning as precedent. If you want to guide the lower courts, write a real opinion. Give us the logic. Give us the guidelines. Do not point to some obscure paragraph and ask us why we did not follow it. Note number 3. Stop for a moment. What we've just described in 3 announcements is the map of the American judiciary being redrawn in real time. On one side, hundreds of district and appellate judges named by both parties who stand firm, who block unconstitutional policies, who write decisions that will stay in the legal history books. On the other side, a Supreme Court with a conservative majority of 6 justices who use an emergency mechanism to overturn those decisions, often without explanation, sometimes in a matter of hours. And at the center of all this, an administration that labels the judges who resist it as radical leftist communists, monsters and fools, and calls for their impeachment when their decisions don't please them. President Trump has stated, and I quote his own public remarks, that we cannot allow a handful of radical judges to obstruct the enforcement of our laws. His Deputy Attorney General Todd Blanche went even further in a speech before the American Bar Association, the leading association of American lawyers. He described the government as being at war with the federal judiciary and urged young lawyers to join the fight. A Deputy Attorney General of the United States who declares war on the federal judges of his own country. That's what we're talking about. And the judges reply, not with speeches, not with press releases, with their decisions, with their words, with the accumulated scholarship of a career dedicated to the Constitution. Like this analysis so far? If so, hit like and tell me in the comments. Do you think the American federal judges will hold? Leave your answer below. I read every one of them. Now, let's talk about what's really happening behind the scenes of the American judiciary, because there are 2 camps clashing, and they're not talking about the same thing. On one side, the Trump administration and its allies describe the situation as a constitutional crisis caused by the judges. The White House spokesperson said the real constitutional crisis lies in the judiciary, where progressive district judges abuse their authority to unilaterally block the president's basic executive prerogatives. That's the version you hear on pro-Trump channels. On the other side, constitutional scholars and former judges like Michael Ludig say something radically different. According to Ludig, cited in numerous public interviews over the past months, every federal district judge has kept his or her oath to the Constitution to the letter. And in almost every case, these judges have collectively ruled as unconstitutional nearly all of this president's initiatives, as the Constitution demands. This isn't partisan commentary. It's the verdict of an old-school conservative, a man who was poised to become Chief Justice of the Supreme Court in place of John Roberts, and who says today that voting for Democrats is the only way to save American democracy. Think about it. Let that sink in for a moment. An American conservative icon, a man whose name appeared on the Republican jurists' Mount Rushmore, is now saying that the only people capable of saving America are the federal district judges, and that the sole obstacle between the American people and the safeguarding of their country is the Supreme Court of the United States. This isn't partisan politics. It's an institutional diagnosis, and this diagnosis is borne out in the data. According to constitutional law scholars cited in the International Bar Association's journal, the Trump administration presents the courts with a concentration of executive overreach based on manifestly inaccurate assertions and fragile legal grounds. Such a flagrant contempt for constitutional norms and fundamental rights makes it harder for judges to rule in favor without abandoning fundamental legal principles. That's what the judges are looking at, and that's why they seek their words in Thomas Jefferson, in the Federalist Papers, in the words of Bob Dylan. Because when ordinary law no longer suffices to describe the extraordinary, you have to look elsewhere. Now, if you live in the United States, if you pay federal taxes, if you have children who depend on a public service, understand what today's announcements mean for you in concrete terms. The Supreme Court's June 2025 decision limiting national injunctions means that if you live in one of the 28 states governed by Republicans who did not challenge the birthright citizenship decree, your child born after that decision may not automatically be recognized as an American citizen. This isn't theoretical, it's already happening. Dozens of thousands of children are in this legal gray area. In October 2025, a federal judge held that the Department of Energy had violated the Fifth Amendment by canceling subsidies only in states that voted for Kamala Harris. According to court documents, Republican states kept funding for identical projects. This isn't politics, it's documented constitutional discrimination, judged and condemned by a federal court. If you work in the energy sector, renewables, state infrastructure, federal research, your budget may have been cut not because your project wasn't working, but because your state voted on the wrong side. And if you tell yourself that the judges will eventually fix this, remember this. For every district judge who rules in your favor, the administration can file an emergency petition with the Supreme Court and obtain a reversal in 48 hours, without explanation, without oral argument, without reasoning. This mechanism exists, it's been used, and it has already worked 20 times out of 25 since January 2025. Your legal protection today depends on the resistance of judges who receive death threats for doing their jobs. I see two paths ahead of us. No middle ground, no gray area. First path. The federal judges hold the line. The 175 former judges who signed the brief against the shadow docket convinced the Supreme Court to change its practices. Institutional pressure, public opinion. The November 2026 midterms force the administration to back down on the most legally fragile cases. American democracy emerges from this damaged period, but standing. The price to pay: years of rebuilding institutional trust, countless lives disrupted along the way, and an exceptional jurisprudence that will be studied in law schools for decades. Second path: the spiral. The administration continues to ignore or circumvent judicial orders, as it did in March 2025 when it continued expulsions despite a stay. The Supreme Court continues to use the shadow docket to invalidate lower court decisions. District judges, facing growing threats and a Supreme Court that routinely circumvents them, begin to doubt the utility of their decisions. The effectiveness of the third branch erodes, and little by little, without formal declarations or a spectacular coup, the rule of law weakens until it becomes a symbolic formality rather than an operative reality. This second path isn't science fiction. The last time the United States witnessed such open defiance of court orders was in the 1950s and 1960s, when Southern state governors refused to desegregate their schools despite Supreme Court rulings. That episode is today universally regarded as one of the darkest periods in American history. It was President Eisenhower himself, though not enthusiastic about the decision, who sent in the National Guard to enforce court orders. Today, the executive branch is the problem, not the solution. I think we're on that second path. But far brighter minds than mine thought the same 6 months ago, and the judges held. They held because they understood something essential. They are appointed for life. They cannot be removed for applying the Constitution. Their only weapon is their pen and their robe, and they have decided to use it. Here's the record. 225 judges, 700 cases, documented death threats, decisions overturned in 48 hours with no explanation. A former legendary conservative judge who signs briefs against the Supreme Court of his own country. A Supreme Court Associate Justice who speaks of Calvin Ball jurisprudence in an official dissent. And everywhere in the quiet halls of the American judicial palaces, men and women in black robes who draw on Jefferson, Madison, and Dillon to find words capable of saying what their eyes see. The constitutional question at stake is actually very simple. Marbury versus Madison 180. Foundational decision. It belongs unequivocally to the judiciary to say what the law is. That sentence has been carved in marble for more than 2 centuries. What we are watching today is the first time in modern history that this foundational phrase is directly tested by the executive branch itself. And now, the real questions, because that's where I want your opinion. Are American federal judges the last guardians of democracy, or are they being assigned a role the constitutional system never intended for them to play alone? Does the Supreme Court protect the Constitution, or does it protect the president who named 6 of its 9 members? And finally, the question that haunts me. When the dust settles in 10 or 20 years, how will history name this moment? A crisis overcome? Or the beginning of the end of a 250-year democratic experiment? Answer in the comments. I read every one of them. It's your analysis that keeps Flash America alive. If this video gave you something you haven't read anywhere else, share it once, share it twice, with someone who doesn't yet know what's going on in the corridors of the American courthouses, and subscribe to Flash America so you don't miss a thing. What we're looking at together isn't an isolated episode. It's the constitutional soap opera most important since Nixon, and it's far from finished.